Welcome back again. The culture of mediation in Italy after the World War II. After World War II, the institution of conciliation is by no means missing from the Italian legal system. The Civil Procedure Code of 1942, Article 183, provides the possibility of conciliation managed by the judge in the pre-trial hearing. Nevertheless, it was always a pure formality. Law 320 of 1963 for disputes before the agricultural sections confirmed the provision that an attempt at conciliation must be made at the first hearing. Law 604 of 1966 on individual dismissals introduced the conciliation attempt at the Provincial District Labour Office, confirmed by the Workers' Statute in the 1970. But in most cases, this has only increased the length of the dispute. Presidential Decree 448 in 1988, in the context of criminal proceedings against juveniles, provides the possibility of promoting the conciliation of the juvenile with the person offended by the offence. Law 146, 1990, on the exercise of the right to strike in essential public services, introduced an attempt at conciliation before issuing orders. Law Decree 546, 1992, introduced judicial conciliation in the tax process, and tax mediation, which is only the name, was introduced in 2011. One area where conciliation has taken hold is that of communications disputes. Law 249 in 1997 laid down a compulsory attempt at conciliation before recourse to the Communications Guarantee Authority. This attempt takes place at CORECOM's regional communications committees, which could also enter into agreements with the Chamber of Commerce and delegate the management of the conciliation to them. However, it should be stressed that these are almost standard proceedings, where there is a very little negotiation techniques. A rebirth of conciliation was to be expected with the introduction of the contemporary justice of the peace, whose activity was geared to the greatest possible simplification. Attempted at conciliation at the first hearing of the case, possibility of receiving in non-adversarial proceedings a request for conciliation, also orally. The means of conciliation constituted an enforceable title. Unfortunately, this was not the case. In the Consumer Code, there is a wide list of consumer rights which can be exercised by the representative associations at national level. Before going to court, they can attempt conciliation before the Chamber of Commerce. And administered conciliation started to be mentioned. In Italy, therefore, there are many articles of law that for the case have allowed, in some cases obliged, dispute to be managed by conciliation. However, until 2010, conciliation was little used. And this is due to the fact that in various areas of the legal system, when the legislator did not know what to do in order to relieve the burden of litigation, he threw conciliation in the mix, generally identifying it erroneously with a transaction, and entrusting it to professionals who often had no specific qualification. In the vast majority, lawyers steeped in adversarial culture or bureaucrats. In 1993, Law number 580 ruled each Italian Chamber of Commerce had to set up a conciliation and arbitration chamber. The Harvard mediation procedure model was the reference. At a very slow pace, ADRs started their way in contemporary Italy. The Legislative Decree number 5, 2003, ruled voluntary mediation in corporate, financial and banking controversies. I repeat, corporate, financial and banking controversy. Very broad topics with a substantial number of disputes. Nobody, Rexus no lawyer, used it. And when I asked why, lawyers replied, because it was not compulsory. In 2009, there were almost 6 million pending civil litigation cases in the overall judicial system, the highest number ever reached. In 2010, compulsory civil and commercial mediation took off. Compulsory civil and commercial mediation took off, and it came into force in 2011. It was revoked in October 2012 and reintroduced in September 2013 with some innovations. Among others, compulsory lawyers' assistance to the parties, the first information meeting free of charge, and the possibility for the parties to opt out of the proceeding. Nevertheless, there was a fierce opposition by lawyers and a benign neglect by judges. Italy has an estimated population of 60 million people. There are 9,400 judges and 242,000 lawyers. In 2019, there were almost 3 million new proceedings filed in civil courts, 147,000 civil mediation proceedings, 20,824 mediated settlement agreements. In the 2011-2019 period, there has been a decrease in civil court litigation, minus 4% per year, because of the economic crisis, a strong increase in mediation proceedings, plus 18% per year, and a strong increase in mediated settlement agreements, plus 14% per year. And according to the European Parliament, Italy uses mediation at a rate 6 times higher than the rest of Europe. Nevertheless, there is a very, very long way to go. In summer 2021, the Italian government is planning to reduce the length of civil trials by 40%. This is one of the commitments with the European Union in order to receive the necessary funding to restart the country and its economy after the COVID-19 pandemic. On June 16, 2021, the Minister of Justice submitted to Parliament its proposals for changes to civil processes and ADRs. Tax benefits, increase of matters subject to mandatory mediation, enhancement of court-appointed mediation, involvement of the public administration, quality of training. Likely very interesting future ADRs developments are in front of us. Nevertheless, to try to predict what it will happen, it's useful to consider what Giuseppe Prizzolini wrote 1 century ago in the Code of the Italian Life, 1921. It is not absolutely true that in Italy there is no justice. It's, however, true that it is not necessary to ask the judge, but that the deputy, the minister, the journalist, the influential lawyer, etc. for justice. the thing can be found. The address is wrong. Moreover, in Italy, there has been neither the industrial, neither the bourgeois revolution, but only the self-replicating fascist revolution, which was the maintenance of the status quo. Therefore, Italians do not like innovations too much. In the Lucchino Visconti 1963 classic movie, The Leopard, there is an enlightening phrase: everything must change so that nothing changes. And last but not least, judicial proceedings usually last too many years. So, in the case of a dispute, many people are aware of a proverb: there is always time to pay and to die. There is always time to pay and to die. Therefore, if there are payments to be made, they are delayed in time. The closing questions are: can knowledge of our society's mediation culture help in the spread and proper use of contemporary mediation? And how can we make the culture of mediation useful? Many thanks for your attention.